Hello people, what's up? So today we are going to do the amendments for old syllabus. You guys have been asking, sir, are we going to do it? Yes, we are going to do it. Why would we miss it? But yes, there is no much major amendments as such. Before you guys come to this particular amendment video, which I'm recording it for the December attempt, December 2024 attempt and onwards. As I always tell, it is advisable to watch at least 2 amendments before you go. So in this sheet also, whatever you guys can see as 2024, now they have given n number of amendments. I won't be covering everything in this. The reason is they have given you an amendments from Jan 1st 2023 to May 31st 2024. So until December 2023 we have already done in the previous video. That is your June 2024 amendments. We already covered. So there is no point in again doing it. So what I am going to do here is whatever is relevant for 2024 December I will be discussing in this. So that's why I would suggest you, before you come here, I would advise you go through the June 2024 amendment video, which is already uploaded on the YouTube. Watch that and then come and watch this particular December 2024 video. I hope this thing makes sense, all of you. With that, let's start. There is no much amendments, people. Absolutely manageable. Absolutely nothing, in fact. See, which we already seen this C-Pace for the exit, right? If you guys remember, there is something new thing that has been started for taking care of exits of the company, like strike off, which we already done in the previous thing. So we are going to do the same thing. Okay. This is something they have added, something called as Central Processing Center. So wherever you can see 2024, most of it will be doing it now. Yes, sir. So they have added something called as people Central Processing Centers. Nothing but it is also called as CPC, Central Processing Centers. Now what is that, people? The government is behind something called as ease of doing business. Now what is ease of doing business? Trying to reduce the efforts of the people wherever it is taking maximum time for them to do a particular job, time consuming and all that. They have tried to reduce it. Now what used to happen, now imagine anyone in India, now if I have to get some work done as a company, I have to file all my requests to ROC, and every state's ROC, they have their own work, and the time taken by the ROCs to process any particular thing was increasing. The time taken was going up and up. So now how do we reduce it? That's why what they have done in the center. So this is applicable to the entire India. They have formed something called as CPC. That CPC only is called as Central Processing Centers. And they have given them the task to handle certain forms. Now whatever previously our regular ROC used to do, the procedure will remain the same. Nothing will change. But wherever we read it as the registrar, that particular job will be now delegated to this particular person, that is CPC. Yes, sir. Sir, everything, sir, everything. There are some works that has been delegated. And the CPC will have 30 days time to undertake this particular work. Sir, this is not there in our syllabus, but just for us to understand, I have just given this for you. What is that here? The registrar of CPC, that is a new person. The registrar of CPC shall exercise jurisdiction all over India in respect of the examination of following applications. So only these things. So if you see, these are the things which has now come under CPC. Should we remember this, sir? Not required, but just for you to know. For example, the ones which you guys already know here also. Most of it you know. MGT 14 you know. Special resolution, now we'll go there. SH7, you know. Share capital, will go there. So as the alteration of share capital, as the case may be. So all these things will now go under CPC. Understood? Why? Ease of doing business, reducing the burden on the registrars, that is the motive. Simple, that is the amendment. See, that's what they have given here. The registrar shall take a decision on the application, e-forms or documents within 30 days. The registrar of CPC. from the date of its filing, excluding the cases in which an approval of CG or RD is required. For example, if at all there is conversion of business, you would need approvals of RD and central government as the case may be. Wherever such approvals are required, of course 30 days cannot be done. It is subject to their approval also. But wherever that is not the case, people, then yes, they are telling you that yes, it will have to be decided by the registrar of CPC within 30 days. Simple. Yes. Okay. Done. The filing fees and all will be same. That's all. That's nothing to worry. Okay. This also again they have not given you in detail, but I'm just telling you what is the gist of it. There is something called as change request form. What is change request form, sir? Now see here, stakeholders are informed that change request form has been made available on V3 portal. What is V3 portal? MCA website, people, in the class, if you guys remember, we used to access a website called as mca.gov.in, correct? We used to access this particular thing called mca.gov.in. Every time this particular website gets changed, upgraded, we give it a name that is only called as version 1, version 2. The current version that is going on is called as version 3. So that change request form has been made available on version 3 portal for the convenience of users of MCA21 services. Okay, this web-based form is to be used only under exceptional circumstances for making a request to the registrar of companies for the purpose which cannot be catered through any existing form or services or functionality available either at front office level or back office level. Now what is that, sir? Now imagine, sir, now under V3, there can be some work I need to get it done. But all my work, I cannot find a suitable form. There can be some work. Now, for example, I might need some, change in the company's details. For example, my date of incorporation is something else. But the one that is reflecting on the MCA is something else. Now, I need some corrections there. There are some errors that is happening. Sir, for all of that, I can use a form called as CRF. Remember, CRF can be used only for an exceptional case. Whenever a particular specific form is already designated, you cannot use CRF. If there is something where you do not have a designated form, only then you will use a CRF. Is this clear? Pakkana? Okay, it is called as change request form. Now that is available under V3 version itself. Not a great amendment, ignorable. MSc 1 and all not required. 2023 already done. 2023 done. 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 See, so easy. Done. Sir, what, sir? Everything you are saying done. Okay. Important C here. Form leap 1. Now, what is that, sir? All of you know something called as IFSC. What is IFSC, people? IFSC means, people, International Financial Service Centers. Just to take care of the financial services that happen between two countries. So it can be investments coming from outside India to India, or investments happening from India outside India, or we want to create that particular place, a specific designated place where we take care of only forex, foreign currencies. We do not want an Indian thing there at all. So with that motive, our government started something called as IFSC, International Financial Service Centers. So there is first IFSC which they have started in India. In the class only I would have told you, it is called as Gift City, which is in Gujarat. So now the question was, people, in Gift City, who and all can go and start their company? It is in Gujarat only. Who can start the company? Anyone can start their company. Provided for that there are some restrictions, entry rules, all that was there. Now, for the companies there, they have started one specific designated stock exchange for Gift City only. So just like we have NSE and BSE, we have stock exchanges specifically designated for Gift City. So only the foreign currencies access will be done there. So foreign currencies will come there for the companies which are listed in that particular center, IFSC. Now my question is, let us imagine today ArivuPro, tomorrow we become, imagine some ArivuPro Finance Limited. Now we want to go and get listed in this, just like imagine we want to get listed on NSE BSE. Imagine we want to go and get listed on Gift City also. Now can I go? Can I do it? Is there a procedure? The answer is yes. That is only this procedure. So before I go there, people, I need to make sure all the compliances required before going there. I've done all the compliances, but what is the guarantee? You need to tell to the registrar. Imagine we are coming under ROC Karnataka, no? I need to tell her, sir, whatever those compliances are, I've done everything, sir. See, I'm filing one form called as LEAP 1. So ArivuPro will intimate our registrar in our jurisdiction. We will intimate that we have complied with everything before going for listing in the IFSC. We will tell, sir, everything required. We have complied. All the regulations are up to date by filing one form called as LEAP 1, which will show us that everything is up to date. And then we can go and get listed there, people. And the stock exchanges there also. There are two stock exchanges in Gift City. One is called as India International Exchange, which is a subsidiary of BSE. Next one is NSE International Exchange, which is a subsidiary of NSE. So these are the two stock exchanges which are currently opened in Gift City. Understood? So today what they have done, they have come up with some specific rules for us to go and get listed in that particular jurisdiction for Indian companies to raise money in foreign currencies. You can go and get listed in Gift City. So imagine we are Indian company, we are a startup or anyone into innovation technology. You guys can go, you can raise money. People will invest money. You guys can get money in dollars. That's the beauty. So for this, they have passed some regulations, rules and regulations. What is the procedure? Sir, do we have that in our syllabus? The answer is no, so don't worry. Clear? Simple. That is this particular amendment. Any doubt? Clear? See here. The MCA has issued companies listing of equity shares in permissible jurisdiction rules 2024. These together provide an overarching regulatory framework to enable the public Indian companies to issue and list their shares in permitted international exchanges. Clear? Yes, sir. What about listed companies, sir? Now imagine Infosys. Can they also go and get listed there? For them, SEBI will issue regulations. That is what they have given here. Clear? For unlisted companies, they have given. This is the regulation. For listed companies, they have to follow SEBI regulations, which is yet to be given by SEBI. That's what they are telling. That's his amendment. Clear? Any doubt? Done? Done. 23 done. 23 done. Same thing that LLP thing and all, again it will come. You need not again worry, just to go through. I hope you guys have already watched the June 2024 amendment. If not, again a reminder, go back and watch. Don't keep on sitting here only. That is more required also. More amendments were there also. They've added some cases and all. Again, same old cases only. Anuj Mittal and another versus Union of India. What is this case? Because of disqualification and deactivation of what is this case? CFS scheme. Okay. What is this case, people? There was a director. Imagine a director called as Mr. X. He was a director of, say, for example, 3 companies. In one of the companies, people, they did not file financial statements and annual return for 3 years. If that happens, what is the immediate thing that will happen? We know one thing. What is that? There will be a disqualification of director Section 167, 164, if you guys remember. So, except in the company in which the disqualification happened, from the rest of the companies you need to quit. Correct? So, what happened, people? This person in whichever company did not file, because of that, people, their DIN and their DSCs were deactivated, which made them not to file forms in the other two companies also. They were not able to access, hence the other two were also becoming non-compliant. So they wrote a petition to the ROC saying that, sir, can you please take our plea that because we did a mistake here, there also a mistake is happening. Can you please look into it? This is not today's case, people. 2020 case law. Today it is not valid. That time, people, there was something called as a scheme called CFSS. This CFSS scheme was nothing but they gave you some time by paying some penalties. It was something like companies fresh start scheme, something like that. So that was a CFSS scheme. So there is a time given to you within which, if you guys do it, if you pay the penalties, then you can this deactivation all will be cancelled. So the court said, when you already have that the fresh start scheme, that is CFSS scheme, then it is not right on your part to deactivate and not to reactivate their DIN and DSC, because that scheme is anyways going on. So as part of that scheme, they have a right to reactivate their DIN and DSC, and that is only the order that was passed to reactivate under the scheme. And this ended in 2021, almost 2020 and 2021, this particular scheme only came to an end. Today it is not there. But once in a while, government will give you an option to do such things. That is this case law. Here, simple. Next one, Surendra Kumar Singhi versus ROC. Yenappa idu? Singhi. Sir, in this case, what happened, people? Again, there was some non-compliance. The company did not disclose everything in board's report. There was some vital information which they missed disclosing in the board's report. If that happens, then what will happen? Every director will be liable. Correct? So there is a non-compliance. Every director will be liable. There is one person who filed a petition that, sir, I cannot be held liable because I am not a normal director. I am an additional director. I am not like a normal director. I will be here only for 1 year. I have been appointed by the board of directors, not by shareholders. And I am a temporary director. For that, why should I be liable for all those non-compliances? In this case, the court held that, remember, the moment you are tagged with a word called director, macha, everything, your duties, responsibilities, penalties, whatever is applicable to a director will be applicable to you also. Whether you're additional or alternative, whatever you call. Even the word additional director, your responsibility is a director only. So hence he was also held liable. That is his case law. Simple law, children. All children case laws. Okay, next one, Yad Guru ido. Pranab Roy is a duty of company who shall inform however as per the resign may also inform in this matter in the what is this? Okay. Simple case of what happened in this case law? A director had resigned from the company. It had been some time. The director gave his resignation to the company, but the company did not forward this resignation to the ROC. So on the ROC's records, this director's name is still reflecting as a director. But whereas he has resigned. And after he has resigned, the company has done something, people, and again there is some non-compliance. And hence ROC has sent a summon for every director, including this director as well. Now the question was, because your name was reflecting in the ROC's records, but in fact, in reality, you are no longer a director in that company. Because it was some transaction that happened post your resignation. The question was, is Mr. X, whoever is the director, is he still liable as this particular director in the company? Because just because your name is reflecting here, in this case they held people, no, it was not. You cannot take it that way, because in reality it was a miss on the company. The company failed to intimate to ROC, so you cannot consider the director liable, because in fact he was not holding the board at all on that particular date. So whatever ROC's notice was, this particular notice was quashed. But technically speaking, people, it is a company's responsibility to file DIR 12. We also know one more thing. There is a form called as DIR 11. If you guys remember, we would have studied as a director may intimate. So if you think the company will not intimate and such headaches will come, it is also your responsibility. I can say it is your duty also to intimate simultaneously, because you also have been given a choice. And that exact form is only called as DIR 11. So in this case, you can also say it that way, that you could have very well used that power also, whereas this person did not do it. But yes, that's the order given. Read here. It was decided by the Honorable Court that the director cannot be arraigned in a matter pertaining to 2017 merely because his name continued to be reflected in ROC. So I cannot take only that as a ground and make him liable, because it's a technical error. As error in 2007 due to non-intimation of resignation by the company. The criminal complaint for default in issuance of non-convertible debentures pertained to 2017, that is after director had resigned. Thus proceedings against the petitioner are liable to be quashed. It came to an end. Clear? Yes, sir. 2023 again we have done. 2023. 23, 23, 23, 23, 23, 23. Watch that. Do not just sit and you also put 23 there. You should watch it. This is, we would have covered in detail. Watch in this one. I think even in SEBI also we have done that. You'll be finding it in SLCM amendments also, this part. Yes. See, that's what I said. There is no much amendments. That's all. That's the amendments. I think there is nothing else. See, this MCA, last time only we had done Ben 4, Ben 5 and all that forms. Yes, sir. Okay, this is nothing you can ignore. They had given one timeline to file the form, but the form was not launched by that time. So they said you can still file it. They have given an extension without paying any additional fees. This was nothing but for BEN provisions, significant beneficial ownership. This is, I wouldn't say a procedural or rule-based amendment. It is nothing, something internal amendment which will not be reflected for your exams. You need not worry. It is something to do with versions and all, so it's okay. You can leave it. Relaxation of additional fees and extension of last date. That is what. So they said from when is the BEN mandatory. They have extended that without payment of any additional fees to 1st July 2024. So now without any additional fees, they can still file this BEN forms until 2024. That's all. Simple. Yes, that's all. I mean, that's not so important also. But yes, people, so that's all amendment is for your company law. Nothing complicated. That's all simple, silly things only. So I hope this can be taken care. And I hope your preparations are going good. Do watch June 2024 amendments. And solve as many questions as possible. Still you guys have time. At least take up one question paper before going for the exam. At least practice one paper. So that's it from my end, people. Thank you so much. See you all. Bye-bye.